Hi, everyone, and welcome to another episode of Coffee Chat. I'm Josh, your host, a partner at Zhonglun Law Firm, one of the top internationalized law firms headquartered in China. Today, we're diving into a pretty interesting topic, patent evergreening, and why it can sometimes violate antitrust law. And I'm thrilled to have my good friend Amy here with me. Hey, Amy?
Hey, Josh. It's great to be here. Patent evergreening, huh? That's a pretty deep topic. But I'm sure we can make it interesting, right?
Absolutely. Let's start with the basics. Amy, you've been in the legal field for quite some time now. How would you explain patent evergreening to someone who's never heard of it before?
Well, let's keep it simple. Patent evergreening is when a pharmaceutical company tweaks an existing drug just enough to get a new patent. The goal? To extend their market exclusivity and keep cheaper generics off the market. It's like playing a game of keep away with competition.
Exactly. And the reason it's such a hot topic is that while companies argue they're just protecting their innovations, critics say it's all about maintaining monopolies longer than they should. That's why China's State Administration for Market Regulation recently put out a draft of the anti-monopoly guidelines for the pharmaceutical sector.
Yeah, that draft really got people talking. It lays out a framework for when patent evergreening might cross the line into antitrust violations. So, Josh, what does that framework look like?
Good question. The draft guidelines say that for patent evergreening to be considered an abuse of market dominance, a few things need to be in place. First, the company must have a dominant position in the market. We're talking serious market power, where they can make decisions without worrying too much about what competitors might do.
Right, and that's not something every company can claim. You've got to be a pretty big player to have that kind of influence.
Exactly. Second, the new patent has to be based on a rehash of existing technology rather than something truly innovative. We're talking about small changes like tweaking the dosage or altering the formulation that don't really add much value.
So, basically, if the changes don't make the drug significantly better, safer, or more effective, it's not considered a real improvement. That's where the trouble starts.
Exactly. And finally, the company's actions like pulling the original drug off the market or bad-mouthing generics have to be aimed at blocking competition. If those tactics are used to maintain market dominance instead of genuinely innovating, that's when it could be seen as violating antitrust laws.
So, China's really cracking down on companies that might be using these strategies to unfairly extend their market control. But how does this compare to what we see in the US?
Great point. The U.S. has been dealing with patent evergreening for a while, mainly through the Sherman Act and the Hatch-Waxman Act. Let's talk about a couple of key cases. First up is the Indivior case.
Yes. Indivior originally sold an opioid addiction treatment in tablet form, right? But as the patent was nearing expiration, they introduced a new sublingual film version and stopped selling the tablets. That didn't go over well in court.
Nope. The court found that Indivior's move without any substantial innovation was an illegal attempt to monopolize the market. It's a classic example of how product hopping, if not done in good faith, can violate antitrust laws.
And then there's the Walgreen v. AstraZeneca case. This one's a bit different. AstraZeneca launched Nexium when the patent on Prilosec was about to expire. Nexium was only slightly different chemically speaking, but it didn't offer any significant therapeutic advantages.
Exactly. But here's the kicker. The court ruled that AstraZeneca didn't violate antitrust laws because they didn't force consumers to switch to Nexium. Prilosec was still available on the market, so it wasn't seen as monopolistic behavior.
That's an interesting contrast to the Indivior case. It really shows how US courts distinguish between hard and soft product hopping. Hard product hopping, where you pull the old product, is more likely to be seen as anti-competitive.
Yep, and that's a key difference between the US and China's approach. China's draft guidelines put a strong emphasis on whether the new patent represents a substantive improvement. If not, it's more likely to be seen as an abuse of market dominance.
Meanwhile, in the US, it's all about the market effects. If the company's removing choices and stifling competition, they're in trouble. But if they're just adding to the market options, even with minor changes, it might be seen as legitimate.
So, where does this leave us? Both countries are working to keep the pharmaceutical market fair, but their methods differ. China's focused on the substance of the innovation, while the US looks at the practical impact on the market.
And that's a critical distinction. It shows that while the goals might be similar, the paths to achieving them can vary widely depending on the legal framework.
Exactly. As the global pharmaceutical market continues to evolve, both countries will likely keep refining their approaches. The challenge is finding the right balance between protecting genuine innovation and preventing market abuse.
And that's a balance we're going to be watching closely in the coming years.
Absolutely. Well, that's all for today's episode. Big thanks to Amy for joining me today. Always great to have you on board.
Thanks, Josh. Always a pleasure.
Some of the insights we discussed today were inspired by an article by my colleague Zhang Peng, published on our WeChat account, Legal Insights. A big thanks to him as well. If you've got any questions or topics you'd like us to cover, don't hesitate to reach out, and don't forget to subscribe to our channel, Yee's Law Journal. Thanks for listening, and we'll catch you next time.